Well, hi, and welcome back to Risk Management. Today, I'm delighted to have my colleague, Matt Whalley, on with us. Matt, thanks for being here.
Hi, Chris. It's a pleasure.
Yeah, and Matt was originally at Burwin Paisner, one of the top law firms in Britain, and started the first legal risk consultancy there. And now he's moved on as a director to Ernst & Young in London and is their head of legal risk management. So, Matt, you've got quite a distinguished background. Tell us a little bit about legal risk and how this topic has evolved and where you see the future of it.
Okay, so legal risk is the study of the way that business operations interact with law and regulation. And it's a study more specifically about ways in which those interactions can go wrong. So in the practice that we set up at Bowen Leighton Paisner and then the practice that I'm building here at EY, we work with clients to help them identify where their business interacts with law and regulation, in what way, and to quantify the potential adverse impact should those interactions go wrong.
Okay, and why would this matter to companies? Why do they need this, and what is it that was not being done in the past that this is now developing into a hotspot area of research and practice?
So there's probably the two things, I suppose. There's the financial impact of getting legal risk wrong is huge. So I've looked at some studies. There are parallels between legal risk and conduct risk as well. So if you look at some studies about the impact of legal risk on financial services as a sector, it's north of $100 billion a year over the last 5 years.
Wow.
If you look at regulatory fines, you probably get to around 100 billion. Then you look at the cost of the investigations, the cost of the remediation, you can at least double that figure. And the studies that those numbers come out of actually are, they look at 10 of the biggest banks in the world. They don't even look at the whole sector. So $100 billion a year is probably low. It could be 250 billion. I mean, the exact figure is pretty uncertain.
And you're just talking about the banking industry and that. You're not even talking about all regulatory sectors.
Banking, insurance, asset management degree, primarily banking, because they've had the biggest issues since 2008. And primarily UK, US banks, although non-UK, US banks have similar issues. The regimes are slightly different, so the penalties are slightly different. If you're a bank in Thailand, for example, your regulatory risk is pretty low.
These principles could apply to other sectors too, right? Like healthcare or mining or energy or something like that?
They could, and they do. Pharmaceuticals, telecoms, oil and gas, and they all have the same level. They all have the same risks because they all interact with law and regulation. And I will explain in a minute exactly those sorts of interactions and the things that we actually think about. But my focus is on the financial services sector, partly because that's it's the nature of living in London, in the city. There's a big concentration of those industries. It's very easy to go around and work with them. The regulatory pressure is much bigger. The financial crisis raised the level of awareness of and certainly the level of penalty of getting legal risk wrong. Certainly where you've got banks dealing with large bodies of consumers. But yeah, absolutely, it's a cross-sector issue. And in fact, in the book that, as you know, that we put together, most of our war stories are actually non-financial services.
Yeah.
We've got car manufacturing, we've got oil and gas, you've got Petrobras is oil and gas, isn't it? So you've got a number of industries highlighted in that, and it really is a cross-sector issue and extremely impactful when it does go wrong.
So in our book, we talk a little bit about the definitions of legal risk, and we throw out in our first chapter a number of different definitions from different agencies trying to look at this issue lately. And Talk a little bit about that for us. Why do definitions of legal risk have to be trotted out? Why do we have to get formal like that? And what are we trying to capture when we give a definition of legal risk?
Right, I will do that.
Okay.
But I said there were two reasons why it's become an issue, and I actually only talked about one. So, secondly, the role. So the second issue is the role of the in-house legal team.
Yes.
So large corporations, financial services, oil and gas, telecoms, manufacturing, they all employ in-house legal teams. And those in-house legal teams have a specific role in advising those companies on those interactions with law and regulations. So they have a specific role around managing legal risk. Because legal risk hasn't been very well defined over the last 15 years, and it leads on to the question you just asked actually around definitions. Because legal risk hasn't been very well defined, and because it's not been very well defined, those in-house teams are under pressure to articulate their value, but only in terms of how much money they save over and above the use of external counsel. So there are, in the UK, we've got something like 20,000 in-house lawyers. So about 20% of our legal population works in-house. Those numbers are probably wrong, probably more, but about 20% as a percentage of the legal profession in the UK work in-house. All of those lawyers, that community of lawyers, are under pressure to justify higher salaries because they're trained as lawyers, so they attract higher salaries. But they actually justify it in terms of the cost that they save over external counsel. They actually have a much bigger role to play in terms of helping firms to identify where litigation might happen, where risks are pre-transaction, adding up risks across multiple transactions, and helping to identify and spot risks throughout the organization before they crystallize into a loss. Because legal risk hasn't been particularly well defined over the last 15 years, it's very difficult to consistently articulate the ways in which losses could be crystallized to build a business case or a good report to management that says, this is the amount of money that we have potentially saved you over the next 5 years by putting in place good legal risk controls.
So,
now,
go ahead.
So the definition is important because you need to have a consistent way of articulating the risks that you're preventing. And I mean, the reason we tackled that initially in the book is that the definition needs to talk to the operational aspects of legal risk. So in the financial services sector, legal risk was defined as part of operational risk in Basel 2003, in the Basel 2003 Accord, and that's pretty much where it's stuck. So that's why we talk about legal risk as part of operational risk. Now, most of the definitions around legal risk are semi-operational. And again, there's a lot more detail in that first chapter, but they're basically sort of a little bit operational, a little bit legal. They talk a little bit about change of law. They talk a little bit about, some very specific instances or examples about how a law could be broken. So documentation risk from the IBA definition, for example, gets quite specific around the type of documentation, very focused at investment banking. What I wanted to do and what I've wanted to do since 2012, 2011, when I started setting up the risk, started really being active in legal risk consultancy, is to get to a standard definition that everybody can work with and that they can adapt for their own organization. So that's where we start talking about the 5 core interactions between a business, operations, practices, processes, and the law and regulation. So that's why we talk about legislative regulatory risk as bucket 1 or pillar 1, why we talk about contractual risk as pillar 2, non-contractual rights risk as pillar 3, non-contractual obligations as pillar 4, and dispute risk as pillar 5. And we break those out because they're quite clear even to a non-lawyer. I say that because I'm a non-lawyer, but they're very clear to lawyers and to non-lawyers that actually, yes, contracts is a key interaction between law and a business. Law, legislation, and regulation is a key interaction. Compliance and assessment of legislation and regulation is a key interaction between the business and law and regulation. Dispute management is a key interaction, making sure you get that interaction right. So that's why we break it down into those 5 and then create more detailed activities or categories within those 5 broad pillars.
Mm-hmm.
Helps to give consistency to the conversations that an individual legal function has with their business, and also helps to create some level of consistency across the sector, across the legal industry, as to what legal risk actually is, and what these in-house teams should be trying to manage on behalf of their businesses as the main function of their day-to-day role.
So in a way, it's sort of categorizing and systematizing issues that people are maybe glossing over or not examining in detail or not formally addressing, and therefore stuff slips through the cracks. Is that why we're doing this?
Yeah, and it came out of the which one was it? What was the ISO standard? There's an ISO or an Australian New Zealand handbook on legal risk, and there's an ISO 31000.
Yeah, I think that's right.
3000, and I think it's 31000. And they're quite, ISO and also the COSO are quite clear that you have to have a systematic approach. You have to have a clear boundary to the conversation about risk, whether it's legal risk or credit risk or market risk. You say, okay, what is the boundary of that conversation? You need to categorize it so that when you talk about a specific category of legal risk, you look at contracts, for example, everybody knows that they're talking about contracts, and then you can get much deeper into how contracts apply to a particular business sector, a particular business unit, or internal function. And you can get into a very detailed discussion about contracting practice, contents of contracts for a particular business line or a particular product. And you can actually start to really drill into the details of where the legal risks are and what the potential outcomes would be should a legal risk be realized as an actual legal issue.
So earlier you talked about how the amount of loss just from regulation alone in Britain might be over 100 billion for the banks, and how much of that is savable through formalization of legal risk? I mean, obviously we'd like to save more money for ourselves if we're a bank, but aren't the regulators, the litigators, and so forth just going to get their pound of flesh at some point anyway, no matter how we try to dice this?
So it's a transatlantic. Those figures are transatlantic.
Oh, okay.
And we could probably argue about which regulator is more interested in getting their pound of flesh, on which side of the pond that is.
We'll plead the fifth on that one.
Hand on heart, as an Englishman sitting over here, don't believe that the regulators fine companies just because they need the money or the Treasury needs the money. I think they have that there are people that argue, and people I interviewed for some chapters of the book that would say that the regulators are have too great a concentration of power. They have the ability to write, approve, and enforce against legislation within the context of the industry they regulate, but they don't. They enforce for a reason, and the enforcement regime has shifted fundamentally because of a realization around conduct in the banking industry, the financial services industry, and a realization that the fines that were being imposed, and the shift happened 2012, probably between 2012 2013 in the UK, when the FCA took over from the FSA. So the Financial Services Authority was split into the Financial Conduct Authority and the Prudential Regulatory Authority. So the regulatory responsibility shifted. So the Financial Conduct Authority is, by the nature of its title, a behavioural regulator, regulates behaviours within the industry. The Prudential Regulatory Authority regulates financial health and the overall system to make sure it doesn't collapse. And it's that shift to a behavioural model and regulating against what people are doing, the reasons that they're doing things within business, what the outcomes are for customers, particularly customers that the regulators feel aren't able necessarily to look after themselves. So on the retail side, for example, where you've got big information asymmetry issues, where the the corporation knows more about the products that they're selling, and they don't necessarily give enough information to the people that are buying them, or don't give enough consideration to the benefits that people might get from those products. So the regulators have got quite clear, they work on clear principles, and they enforce against those principles. They enforce a hell of a lot higher than they used to. That's because they had to find a level that would initiate genuine behavioral change in the firms that they were regulating. And regulation now has gone on, to my mind, legal risk compliance has moved from a cost of doing business, to accepted cost of doing business, which I think it was pre-2012, to an actual behavioral changing level of fine.
So it's not just about sort of imposing fines or sort of graft in the system so much as there really is a top-down systematic change of management structures so that risks are not as prevalent or as severe as they used to be.
Yeah, I mean, the regulators don't specify necessarily what firms should be doing and the way that they should manage risk and legal risk. There's a discussion paper at the moment to talk about where the in-house legal team sits within an organisation and what the role of the general counsel should be, whether they should be held singly accountable for legal risk, something to do with it's part of the senior managers regime over here. But there's the theme behind the fines, the point I was trying to get across, the theme behind the fines is to instigate behavioural change and to inculcate a better culture within that sector. And I think you'll find that there's the theme is one of non-contractual obligation, is one of duty of care. And the regulators are incredibly focused, whether they articulate it this way or not, around ensuring that companies are aware of and live up to that duty of care.
And we had a co-author in one of our chapters, Mel Schwartz, who says that general counsels are oftentimes sort of reactive, and they just sort of farm stuff out when things get sticky and things have come to bear and it's aware of it, the risk is manifesting. They are just sort of reactive in the sense of farming out to other people to deal with in a reactive crisis. Do we anticipate sort of preventative measures here being taken? Is that what we're trying to do, is get ahead of the risk also in legal risk management?
Yeah, that is the be all and end all and point of it all, is to work out how these crises happen, and to get to the root cause and stop this and stop the root of the event so that you don't. It's about creating demand suppression by finding risks and eliminating those risks. And Mel's right, most in-house lawyers would freely admit that they're very reactive. They are very time poor. They are trained, I mean, lawyers as a profession, they're trained to work incredibly hard, to deal with whatever's put in front of their desk, to pull all-nighters as a sort of badge of honour. And although, the older they get, the less likely they are to do that, they still are used to working incredibly hard, and they'll deal with peaks in demand, the spikes in demand, they'll deal just by working harder and hope that goes away. But what's happened is that those spikes have become a new normal work level, and there are all sorts of cost pressures that again have been brought about, post-crisis and all the financial events that have happened. But so there's a greater pressure on cost for in-house legal teams. There's an increasing amount of legislation and regulation and an increasingly litigious environment, and they're in the middle of and because of the pressure on cost, they're being asked to do a lot more with either the same or less resource. So they're almost in the middle of this kind of perfect storm, where the only answer that they have to the increasing work levels is because they're not allowed to hire more people or to increase their external legal spend, they have to find ways of suppressing that demand on their time. And legal risk management is the way to get into the business, find out exactly what it is at a behavioral level that the business is doing that is resulting in legal loss, and helping to correct those behaviors, whether they're through staff, whether they're through documentation, but helping to correct things that are happening to ensure to suppress that demand on their time.
Could you give us maybe a war story, if anything comes to mind? One thing that I was thinking of along the lines of what you were just talking about was we give the example of VW in our first chapter, and the crisis that came about for VW that manifested with their diesel engines and the sort of fraudulent testing that was going on there.
Mm-hmm.
Are there examples where legal teams should be able to get ahead of root incentives like that? Why does something like VW happen where billions of dollars are put at stake? How do legal teams get ahead of things like that to make sure that those sorts of firm-wide systematic crises that are potentially going to sink the firm don't happen?
It's very difficult to imagine how a legal team would be able. It's not actually so difficult to imagine. On the face of it, it's difficult to imagine how a lawyer would be involved in the engineering activity to that level of detail. But the legal team should be aware of the environmental regulation and of the other laws and regulations that apply to the design and development of those bits of engines, and they should have a feed into the culture around that design and development and awareness of the risks of it's essentially a kind of it's a version of fraud, right?
Well, I'll give you another example from the banking sector we've just had that is maybe closer to what you work with normally. Is here in the United States, we're having a crisis manifesting with Wells Fargo lately, where apparently Wells Fargo tellers and other bankers were opening fake accounts on behalf of customers and even credit card lines, and even charging sometimes on those credit card lines to try to hit their bonuses or targets for commission sales. And this was going on where millions of accounts had been opened over the course of 4 to 5 years. I even have students who have told me, they had worked for Wells Fargo and that this was known practice going on sort of firm-wide. And of course, now the CEO has resigned or is resigning, and all of his bonuses, I think $40 or $50 million in bonuses, have been clawed back as a result of concerns with the company, and it's been brought before Congress and so forth. Obviously, when you have this sort of epic meltdown in practices, is this just something where things in the culture built over time in the firm culture, and sort of systematic abuse was tolerated at the top levels, or is this something that management just wasn't aware was going on at the lower levels? How do we get ahead of those?
Well, I don't know, of course, what happened or what is happening at Wells Fargo and anything that came about there. In general, to your point, the potential disconnect between what the board are aware of is happening and what's actually happening is a key source of concern and of potential legal risk. So the governance of the organization is a key source of concern, and getting that governance right, getting the legal risk management right within the board, but also getting the board the information that it needs to speak to legal risk, and getting legal risk to cut across a broad swathe of operational risks that individually make it difficult to find that kind of, to pinpoint that kind of event, and to pinpoint the potential risk or the potential loss related to that. What's probably it sounds like a series of individual events, although with a culture of acceptance that you wouldn't want. But if you went to the board of that company and said, how do you feel if we set up lots of fraudulent bank accounts and steal money from our clients, assuming that's what's happened? I bet you they wouldn't say, that's great. I bet you they would think, of course, well, that's not what we do as a bank. Of course, we're not going to do that. But so you would assume that there's a disconnect there between actually what's happening and what's happening at the board, but you cannot excuse the fact that the board had no awareness of what was happening. And one of the big picture legal risk controls, it's probably chapter 2, the book is about how do you get that governance right, and how do you report up to senior management and management at board level what the behaviors are within the organization and what the potential risks of that might be. And you would think that if a lawyer was reviewing operational behavior at that level, and finding out, doing some interviewing staff and finding out what was happening on a retail banking deep dive, that this sort of behavior would come up and would be flagged as a significant it would probably be a significant extreme risk. Or it may even be the most significant typical risk you could possibly find, because you're expecting, if this is actually the day-to-day practice, you're expecting it's going to go wrong, you're going to have to disclose it to the regulators, and therefore it's a loss waiting to happen. But you would hope lawyers would pick that up a lot earlier rather than it being found out. I don't know how it came to light, but you would hope that if you had those legal risk reviews going on consistently every year, that sort of issue is going to be picked up and dealt with before it becomes a macro level bank-wide issue.
Yeah, and we talk about this in chapter 2. I don't want to spoil us by jumping ahead chapters when we'll talk about sort of value management and so forth in companies. But in this case, I think customers themselves were sort of picking up on, hey, I've got this account that I'm being charged $50 on, and I don't even know what this account is, and so forth. So it was actually reaching outside the company where people were doing that. I guess in listening to you, though, a board is only 8, 9, 10, 15 people or something like that who have limited time and resources and so forth. Is it fair that we're pinning when you have such unwieldy, huge organizations with thousands of employees and very complex interactions and so forth, is it fair to let the blame all lie at the top? I mean, is that how we're going to sort of ultimately hold people accountable for risk, or can we somehow stratify the risk through the system so that it's not all just sort of rushing up to the top, that the top always suffers as a result?
So the issue that people that found, there's a Walker and Kay reviews in the UK about corporate governance and looking at some of the failures around 2008 and the difference between some of the companies that survived and some that failed. There are some companies with identical balance sheets and business lines that went under, and others succeeded. And they looked at the difference between those two and found that actually having a good, robust, aware board was the key difference. And the board, whether it's 8 or 10 or 15 people, is the group that is responsible for the strategy, direction, and ultimately the culture of the firm. It is fair for them to be accountable for huge breaches in culture and that result in that sort of behaviour. And the Walker and Kay review have implemented a new set of governance rules in the UK that I think are being adapted. There's an adaptation in the US as well, to make individuals accountable at board level. And the senior managers regime that's been brought in financial services is very much targeted at making individual people accountable, but not just at board level, at another level or two beneath that. So where I was talking about the role of the general counsel, if they are designated as a senior manager by the FCA, if that role is designated a senior manager role, they have a duty to disclose to the regulator anything that they think may be a significant issue within the company. So there's that's happening here. I don't know whether the same thing is happening over in the US, but that level of accountability isn't just applicable to financial services. It's part of the corporate governance code that all corporations have to sign up to. So I would say that if you are running a company, you should have a good awareness of what's happening within it. Absolutely, it's more difficult to have that level of awareness the bigger your company becomes, which is why you have to implement robust risk management policies as well as remuneration, and you have market risk, credit risk, and liquidity risk, and you want to have strategy committees. There's a lot of structure that goes into managing a big organization. But what happens if you just implement a structure and then don't get feedback from that? I can't claim the phrase, but I heard it from a client a few months ago. If your board isn't hearing the echo from the bottom, if the tone from the top isn't accurately reflected in the echo from the bottom, then you've got a problem. But you only know about that problem if you're getting that reflection back. And that's where the reporting, that's where the risk management frameworks, that's where the definitions and the clear articulation of what risks you're looking for and managing, not just in legal risk, across the whole swathe of risk management, where that's incredibly important. Because if you've got a clear articulation of the risks that you're managing, and you can clearly articulate that to people at the front line of the business that are actually signing you up to all these risks, either through their day-to-day behavior or through the contracts that they're writing or through their behavior inadvertently breaching some legislation or regulation that applies to a particular product or service or business line. You're not taking, you're being overly aggressive in disputes, not registering intellectual property, not being aware of a particular duty of care they have to a customer if they open up have a conversation and then ending up in some sort of fiduciary dispute. There's so many ways that you can get it wrong. And you need to have an awareness at the bottom of at the front line of the company as to where the risks are and what people do as individuals. That then gets reported up through lines of management, and ideally through systems and technology that can even cut out lines of management, so you can get these flags straight through to the board and say, okay, these are all green, but why is this flag red? What's happening in this business line, in this geography? What's actually going on? So they know what's going on in the business. And that's a frustration, I think, for boards at the moment, is that they're finding it difficult to get that information from their businesses, because they're not used to operating in that sort of end-to-end way.
We talk about in chapter 1 that you can spend good money or bad money in legal risk management. Is that sort of along the lines of what you're just describing? What's the good money? What's the bad money I can spend if I'm trying to do legal risk management?
No, that's a different thing. So that, again, I can't claim that that's from a client who's probably far cleverer than both of us, certainly than me. But they said in their opinion, there's good money and bad money that a general counsel could spend. Bad money is crisis management, fighting a dispute, lawyer time trying to put out fires. That's bad money. Good money is preventative. It's spending £20,000 on a contract review to prevent a £2 million dispute, or it's doing a deep dive of a particular business unit to find out where the risks are because you've seen a spike in legal issues coming out of that business unit in the past 12 months. It's that kind of preventative spend that they were talking about, which is exactly where the legal risk frameworks and legal risk management comes in.
EY is certainly at the forefront of what's going on in legal risk management. That's why you're there, and you're one of the pioneers of this. Talk a little bit about how you see the consultancies, the Big Four and others, fitting into this picture with large firms, the banking sector and so forth. Are these practices always going to require outsiders, or are you training up cadres of insiders in these companies to eventually help themselves, or how does that synergy work? Do you bring in legal risk managers at various times, or do you embed them ultimately with people where you staff people from EY into those companies? What will be the sort of dynamics of the legal risk enterprise?
So because this is relatively new, as an industry, legal risk management is relatively new as a defined industry. I think lawyers would claim they've been doing it for hundreds of years. But there are, every in-house lawyer has a role. Their role is, primarily legal risk management. But they generally do that through a transaction or crisis management work. So they'll advise on a transaction to minimise the risk within that transaction, or they'll advise on a crisis to minimise the potential negative outcome of that crisis. Very few actually do it at a second line level. And I'm sure your students know about the 3 lines of defence, or we'll get onto that in another conversation. But lawyers are good at the first line transactional crisis management work. They do naturally do some third line audit review work, but that second line of defence risk management work actually is very underdeveloped within in-house legal teams. The aggregation of information across risk types, or across work types, reporting of information down particular risk lines or across business units or geographies, that's not really done very much. So I think there'll be a few phases. So there's an educational phase, which is part of this program, and the book is part of educating in-house lawyers into what we mean by legal risk management, what a good view of legal risk management is, and then how to actually address it systematically within whatever organisation you happen to work in, in-house lawyers or not. It doesn't really make too much difference. And if you have an in-house legal team, first step is to get them up to speed on what you want them to do. But because in-house legal teams genuinely aren't sitting around just waiting for the phone to ring, they're genuinely, in my experience, incredibly busy because of all the issues we were talking about before. They don't have the time and the resource to actually implement anything, any significant change program. And when you're talking about implementing a legal risk management framework, it's a change program effort. And I see that being better owned within a risk management function, with the legal team inputting as subject matter experts. So bridging the gap between the legal team and the risk management team is a core thing that we're trying to do here at EY, and helping both of those core functions to wrap their arms around legal risk, pinpoint where the key potential losses are, and put the right mitigation processes in place. In 10 years' time, it would be great if all of the in-house lawyers that are coming through, get legal risk management, new structures, align around legal risk rather than around legal transactional advice. Risk management and legal work more closely together. Compliance get brought in again, rather than sort of separating out because of the prevalence of compliance risk at the moment. And that everything starts to work around just picking out and identifying key sources of loss, whether they're legal or operational. It's the interaction of law, regulation, and business operations that matters, and getting that interaction right and managed is what's important. Having said that, because it hasn't really been done systematically, if you're a significant organization, you're going to need to do a significant review of those interactions to pick out and pinpoint where the key risks are, so that you can start to move from that initial effort, and energy gets put into that effort into a business as usual that can be managed by in-house teams. So I think the consultancy side has a key role to play right now in education and strategy, and an incredibly important role to play moving further down the line in identification and quantification of the risks. There's then a further piece. Once you've identified, quantified, how do you actually wrap good controls around those risks and put the right reporting mechanisms through and identify key risk indicators and do all of the things that you want as a general counsel or as the member of a board, so that you can get the information about legal risk and make sensible, informed decisions about what you should do with your business. So there's a big role to play for the consultancy market. As you say, I built the first one, at Bowen Lake Paisner, building it up again here. But here at EY, we have huge risk advisory practices that can deliver that analysis work, that can do the legwork and implement the big programs. So we've got the strategic, educational level understanding about what legal risk is and how to design and implement a good legal risk management program. And we've also here got the resource and the skills and expertise that has been built up within the firm for many, many years, but how to implement and how to investigate big risk projects.
Matt, for my students, what are the attributes, the training they should have, the experiences they should have if they want to become proficient risk managers and they want to either embed with companies or become consultants or things like that? What sort of training experience do they need to bring to the table?
Bloody hell. Are they lawyers?
Yeah, some of these are lawyers, and some are people working sort of for masters in law degrees where they have some sort of accounting background or finance background or something like that, and they want to sort of supplement where they're not necessarily going to become lawyers, but they'll get legal training through these courses.
Blimey, that is a big question. So I believe that lawyers are naturally trained as risk managers. And I believe that partly because Nassim Taleb said it at a conference, that he thinks that lawyers are the most natural risk managers. You are trained as a lawyer to think through potential consequences of actions and actually to try and quantify and put in place mitigants around those consequences, which is classic risk management. The problem is that legal training directs you towards potential litigation as the sole form of risk. And all I think and that's wrong, by the way, I think, and that actually, once you're in dispute, you've mismanaged something further down the line, and you've got a different set of risks you need to manage when you're in a dispute. So I think what's needed really is just a shift in perspective for lawyers, that actually dispute isn't the risk that you're trying to manage. You're managing potential operational failings in delivery of contractual obligations or in adhering to contractual rights. That law and regulation isn't a risk in itself. It's the way that you interact with them. It's failing to understand which laws and regulations apply to your business. It's misassessing the potential outcome of non-compliance, or it's not understanding the importance of IP to a business, or the business not understanding it fully, and the risks of somebody else being able to legally take your IP, or of you inadvertently taking somebody else's, and then on the non-contractual obligations, what is duty of care? How is it developing? How is the ethical environment shifting, or the way actions are viewed through the ethical framework? How that is shifting to just again stay ahead of where regulators are going from an enforcement perspective. So, I think I don't really know what makes. I think lawyers have a natural advantage when it comes to risk management, except the inability to do maths and use spreadsheets and all that sort of traditional "you're lawyers, so you don't know about numbers" kind of thing. I think that's less of an issue now. The lawyers I meet coming through are far more au fait with that thing, and I don't think it's a particularly lawyerly thing. I think it's just it's one of those generalizations, I think. So you need to do spreadsheets and reporting and all that sort of stuff as a risk manager. But it's just being able to think through potential consequences and how they could go wrong. And I think lawyers are naturally aligned intellectually and by training to do that.
Do they build this up? We pointed out the deficiencies, which I think you're correct about the school training and how it's sort of divorced necessarily from the skill sets that you need to identify and be proactive about risk. How do they build those up? Just by going into practice and getting thrown in the trenches and taking their losses and learning as they go? Or are there ways that they can be smart about getting that experiential know-how and intuition to deal with these things?
I think, I kind of, based on my own experience, it's experiential. I think this course is probably the first legal risk management course. There might be some that would argue, but we'll say that it is. It's the first legal risk management course for all of Chris's students. At least one of the first three. I can maybe think of one other that was done at LSE, but a very, very different bent and not really risk-based, more legal-based. Certainly one of the first. Certainly the first with that we've got this sort of video conversation and the much more broader audience. This is a key thing. The book is a key thing. The articles that people write about it. What you need is to build engagement in law schools, universities, around how the law is applied. I made a comment at a conference over here maybe 18 months ago to one of the schools here that delivers legal practicing certificate training. So the year you have between getting your legal degree and then being able to have a training contract, you have to do a year called legal practice certificate. I don't know if it's the same way you are. And I asked them whether they were going to start teaching legal risk management, and they said, "Oh, we've been doing that for years." But they don't teach legal risk management. They teach how to avoid disputes or the stuff about the law, not about how it's applied. And I think you need more engagement from universities in providing outside lectures from people in industry. Would be a good start on practicing legal practicing certificates. That sort of legal qualification. Having some sort of risk management module in there would be really useful. And again, another good step. Masters, so any sort of master's degrees around. I don't know whether it would be purely legal risk, but something that has that commercial application in it. I'm actually seeing more interest from law students in doing dissertations around legal risk. I did my first. I helped to mark, or whatever the official term is, a student of Tobias is in Norway, one of his students' legal risk papers, and I've had 2 or 3 students approach me just through social media to say, you know, what if I was going to do a thesis, could I do it on legal risk? What would you think? So I'm seeing more interest from students around it. And I think it's just a question of nurturing that and helping it to develop. For now, because it's quite new, you know, hopefully more and more materials will be written about it. We'll get more theses. We might get a few PhDs on out there, and actually it'll start to, over time, embed itself in the education of lawyers coming through.
Great. Just one more question. I think we'll wrap up then for session 1 here, and this has been a great overview for everybody, which is, can we eventually see legal risk management percolating down to even small firms? Let's say I've got 50, 70 employees, and I maybe have a general counsel, 1, if any, or at least I have somebody who's a partial general counsel who lends part of their time to in-house work. Could we see that these principles, which, you know, currently you're mapping onto large institutions, could they be distilled down even to help small firms in their businesses, or would we have to apply a different approach?
Yeah, no, absolutely applies to small firms. It's just it doesn't take so much effort to implement because it's smaller, so you haven't got the same number of interactions or the same number of individuals that you need to work with. So easy to do it for a small company, and actually there are many companies bigger than 200 people that don't have an in-house legal team, and they still have legal risk. And if they don't have an in-house legal team and they only instruct lawyers to, you know, paper deals, then they're not dealing with those risks at all. So there's possibly a greater urgency from a basic commercial dispute perspective for those smaller companies that only instruct lawyers to do paperwork, essentially, you know, to actually get a good legal risk review to see where the potential risk areas are, and to actually manage them properly.
Could they do that through external sources like EY, or do they eventually need to embed a risk manager in their company? Do they actually have to hire a line item, somebody who's really going to come in and do this, or can they do it through those third-party consultancies?
It depends where they are in their progression, right? I'm not sure what the line is between it being worth just outsourcing something and actually employing somebody part or full time to do it. You probably start with somebody at a INED, non-executive director level, helping to design and implement for that size of a company, design and implement it, or design something and then getting that embedded in the organisation. So to do it that way rather than take somebody on at the ground, just depending on size. You know, there's so many variables in there, but they certainly should be looking at it. To my mind, even if it's just 2-3 day, you know, brainstorming session to work out where things are.
Great. Well, we're sort of wrapped up for time here on the first session. Is there anything you want to leave the students with that we haven't covered in sort of an overview of legal risk management, or have we covered enough ground?
We've covered why it's important in terms of the form of loss. Talked a lot about financial. Obviously, the reputational impact is at least as big. And on the VW example you were talking about, the research I did turn out it was a 6 billion euro exposure, but a 30 billion euro impact on brands. So the reputational impact is absolutely huge. I talk a lot about financial services, but it is cross-sector and important for businesses of all sizes. We've talked about the 5 pillars, so legislative, regulatory, contractual risk, non-contractual obligations, non-contractual rights, and dispute. And we've talked a bit about governance and culture. I think that's probably enough for what is it? A Thursday? Probably enough for a Thursday evening.
Well, Matt, thanks for joining us in this first session. We'll look forward to seeing you in a future lecture.
All right, real pleasure, mate.
Thank you.